Knowing your rights as an Indiana renter. This video is not a substitute for professional legal advice. This video does not create an attorney-client relationship, nor is it a solicitation to offer legal advice, but for education purposes only. This video was produced in June 2021. Laws change, and it is important to talk with an attorney about how current laws may affect your case.
Hello, and welcome to the short video series, Knowing Your Rights as an Indiana Renter. In this video, you will learn more about your right to safe and clean housing. In Indiana, landlords are required to provide rental units that are safe and clean and comply with all building and health codes. Specifically, a landlord must provide and maintain electricity, plumbing, sanitary systems, heating, air conditioning, and elevators if provided, and appliances supplied with the unit. The landlord must also take care to keep the common areas safe and clean. In Indianapolis specifically, all landlords should provide a notice of tenant rights and responsibilities with all new lease agreements. What should you do if the conditions are bad? You should be familiar with what your lease says and what your responsibilities are. By law, the responsibilities for fixtures such as electricity, plumbing, sanitary systems, heating, and air conditioning belong to your landlord, and your lease shouldn't say otherwise. First, notify your landlord. You must alert the landlord of the problem and give a reasonable amount of time to make repairs. Create a paper trail by notifying your landlord in writing, such as in an email or text message. And remember to save those communications. For your convenience, you'll want the repairs to be made immediately, so give the landlord access to your unit as soon as possible. If you deny access to the unit and there is damage, you could be held responsible for damages. Second, give your landlord time to make the repairs. If the landlord fails or refuses to make repairs, do not withhold your rent. If you do, the landlord can have you evicted. It's more beneficial to pay your rent as agreed under the lease. And later, you may have an opportunity to file a lawsuit against the landlord and get some of that rent money back. At this time, it's also a good idea to contact your local public health department. They'll do an inspection and send a letter to the landlord about any violations of local health codes with a demand for repairs. Third, file a claim in small claims court. If your landlord still refuses to make repairs, they have violated the warranty of habitability, which is their obligation to maintain a safe and clean environment. You can ask the court to force the landlord to comply with building and health codes. Once a claim is filed, a hearing will be scheduled within 3 days. You should contact an attorney to assist you with filing a claim, following court rules, and presenting your evidence to the court. The inspection report from the Public Health Department, pictures, and witness testimony from yourself or others can help the court understand how the landlord violated the warranty of habitability. Let's go over some frequently asked questions about your right to safe and clean housing. My lease says the tenant is the only one responsible for maintenance. Is this true? No, the law applies even if the lease says it does not. It cannot be waived. The lease may still say something about who's responsible for things like minor repairs and lawn care. The requirements of the law will still apply. Either you as the tenant or your landlord can sue in court for damages, orders to repair, and attorney fees. If you violate the lease, however, most landlords may choose to simply file for an eviction. What can I expect my landlord to do about noisy or disruptive neighbors? The landlord has a duty to protect every tenant's right to peaceable enjoyment of the property. It's the landlord's obligation to investigate the situation and take action, which could range from a warning up to involving law enforcement or eviction. Whose duty is it to exterminate for mice, insects, or bedbugs? If your lease doesn't specify, it's probably safe to assume it's your landlord's duty to exterminate. Notify your landlord immediately upon the discovery of an infestation, such as rodent droppings, termites, or bedbugs. Check your lease. It's not uncommon for landlords to include in a lease that bedbug treatment is the responsibility of the tenant. Any delay in taking action can make the problem worse, and you could be held responsible for the damage caused by your delay. Here are the 3 steps again that you should follow when you feel like your living conditions are bad. 1. Notify your landlord. 2. Give your landlord time and access to make the repairs. And 3. If the landlord still doesn't act, file a claim in small claims court. Thanks for watching and learning more about your right to safe and clean housing. Be sure to check out the other videos in the Knowing Your Rights as an Indiana Renter series. Videos are available on protecting yourself from eviction, understanding your lease agreement, housing discrimination, and reasonable accommodations and modifications.
This video is not a substitute for professional legal advice. This video does not create an attorney-client relationship, nor is it a solicitation to offer legal advice, but for education purposes only. This video was produced in June 2021. Laws change, and it is important to talk with an attorney about how current laws may affect your case. Many resources on this housing topic and others are available at www.in.gov/courts, www.indianalegalservices.org, and www.eskenazihealth.edu/medical-legal-partnership. Knowing Your Rights as an Indiana Renter video series sponsored by Eskenazi Health Foundation.